loud and clear. Health and Wealth Radio, WNN.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Are you a family caregiver? Are you caregiving for someone who can no longer take care of themselves? Are you overwhelmed? This is Caregiver Solutions Info with Marcia Teal. Marcia will be hosting an hour of true stories and information, tips and updates of the latest research and necessary information in the caregiving field, focusing on you, the family caregiver. An Alzheimer's disease and dementia care expert, Marcia has 15 years of hands-on experience at Arden Courts, a leader in assisted living dementia communities here in the U.S. Marcia covers everything you need to know as a family caregiver, especially if you care for a loved one with Alzheimer's disease or other related dementia or chronic illness. If you have a friend or relative that is also a family caregiver, call them now. They won't want to miss a minute. And let them know they can watch on caregiversolutions.info. And they can listen on WNN 1470 AM in South Florida or nationally on the iHeartRadio app. Now, sit back, relax, and learn from our host, Marcia Teal, as she brings information to you that may just be the caregiving solution you need.
Hi, everyone, and welcome to Caregiver Solutions Info Show. I'm so happy that you could join us today. If you're a family caregiver or just a concerned person who wants to know more about caregiving, about Alzheimer's and dementia, about all the things that we need to do and plan for as we age, then this is the place for you. This is live show out of Boca Raton. Very excited that you're here today. We're here every Tuesday, 5 to 6 Eastern Time, with lots of experts that come on to the show to lend their expertise, their experience, their advice, really good stuff for free to caregivers who need to learn. So if you can't get out to seminars and you don't particularly like to read a lot and you just want to listen and watch and learn, then you've come to the right place. So today we're going to be talking about something very important. It's legal issues. Now, everybody has occasion in their lifetime to need an attorney. And you probably know there's lots of different types of attorneys. There's attorneys for real estate, attorneys for when you have a car accident, for injury, attorneys for getting divorced. I mean, there is so many different kinds. But did you know that there's a difference in attorneys when it comes to your elders? And a lot of people don't know that until they come to that bridge to cross and think, what do I need to know? Who do I need to go to? And who is the best person to help me in this situation with either my spouse, who needs some additional help because of a health problem like dementia, or if you're an adult child and all of a sudden you're faced with helping your parents in a situation where you find yourself needing legal advice. So we're going to talk about legal issues here today, but we have a special type of attorney with us. It's an elder law attorney, and she is one of the best. She's been in practice here in the Boca Raton area for over 20 years, and she is so wonderful, and I'm going to introduce her now. Her name is Sherry Greenblatt. Hi, Sherry.
Hi, Marcia. Thanks so much for having me on.
I'm so glad that you're here. Sherry, you have been around a long time, and that's why I'm glad to have you here, because you have a lot of knowledge and expertise. You're also board certified, which we're going to talk about what that means exactly. Your company is called Florida Elder Law Concepts.
That's correct.
Professional association, and you're the principal of that.
That's my firm.
That's your firm. So let me just start out, let the people know that are listening or watching with us today. You've been in practice about 20 years, correct?
That's correct. I'm in my 20th year practicing solely elder law. It's the only area of my practice. And like you mentioned before, the legal profession has specialties, just like the medical profession has specialties. You break your arm, you're not necessarily going to your cardiologist.
Right.
You want an orthopedist. The law is the same way.
Right.
We have specialties.
So you are a specialist, and you know,
that's correct.
Bring great people onto the show, and I can't wait to get into this. But you picked a specialty in elder law. Explain what elder law is, and how does elder law practice differ from a regular attorney who helps older people, I guess. Is there a difference?
There is a difference because of our focus. Elder law as an area of practice has really not been around that long, maybe 30 years, 35 years, I'm approximating, but estate planning, for instance, has been around for literally hundreds of years, and dating back to England. But elder law, in essence, says, I want to do estate planning. I want to make sure that my assets get to my beneficiaries that I choose, the way I want them to receive it, with the people that I choose in charge. And, oh, by the way, let's minimize taxes.
That's always a good thing.
Exactly.
So in the past, people
would go... But elder
law
is different.
Right. So people would go to an estate planning attorney to do those. But there's more to it as we age, right?
That's correct. So elder law really came out of that and said, yes, I want to do all those things. I want to make sure my estate plan is as I want it, not as the law says it is if I don't plan.
So you have a say-so.
Exactly. But wait a minute. I'm going to be retiring. Medical science is keeping me alive longer. Diseases that used to shorten my lifespan are manageable now, have become chronic.
Right.
I can live a long time with them.
And people are living a lot longer.
Absolutely. My eldest client passed away 2 years ago. She was 108.
Wow.
And one of the fastest growing populations in my practice is the over 95 crowd. And I can tell you, they're going to outlive all of us.
Wow.
God bless them. And I had one client, she had just turned 99. She came into my practice one day. She said, you know, I just turned 99. It's time I name my daughter as my co-trustee. Because you never know, I might need her help.
Nothing like waiting till the last year.
Exactly, and it's a good thing she did, because 6 months later she fell.
Oh boy.
And she didn't pass yet, but she had she needed assistance.
Okay.
But she made the decision. She made the decision for her daughter to have the legal authority to assist her with managing her affairs.
And that's what this is all about.
That's what it's all about.
It's for people to be proactive and to have a say-so in how they want things to be in their life as time goes on, all the way from getting older to passing away. Because part of the legal documents that we're going to be talking about address those things. So
that's correct.
yeah,
absolutely.
So why did you choose the elder law specialty? Is that a passion of yours?
It is a passion of mine, and it goes back a number of years. When I was in law school, elder law was not taught. There were no elder law courses. However, I went to school in New York. I am admitted to the New York bar, but I was offered a job in Florida. At the time, Florida didn't have the ability, or they didn't authorize to waive in, so to speak. So I wound up sitting for the Florida bar.
So you had to get licensing in both states. I had to get licensed in both states, and I did. Thank goodness I passed the first time. And I moved to Florida because I was offered a position down here, and I fell into being a caregiver. Most people don't just wake up one day and they're a caregiver. And I say that all the time, so thank you for validating that.
I fell into it. What had happened when I moved down is my grandfather's health started to fail. It started to decline. He had been my grandmother's caregiver, and she passed away the year before I moved down. And his health started to decline. His children were out of state. I was young, single,
and had plenty of time.
And I had a position, but it wasn't, my hours weren't crazy. It was much more flexible. So I basically learned elder law on the job as a caregiver. And it started out with just cooking healthy meals for him instead of him going out to restaurants every night, and accompanying him to doctor's appointments. Always important to have a second set of eyes and ears.
Absolutely.
At the doctor's office. At the time, he had full capacity. He could listen, make his own decisions, not an issue, but doctors are like lawyers. They speak another language, especially when the subject matter is difficult. So to have another set of ears there,
and maybe to ask
important.
And to ask questions that maybe you might not think of, even if you have full capacity, mental capacity. Sometimes there's questions that, because you're stressed going to the doctor or you just don't think about, that somebody else can ask the doctor. And that is a great point to make for people. If you have an elderly person, even though they can still make their decisions. Absolutely. But that is a great piece of advice.
Absolutely. That second set of ears at the doctor's office. And as time marched on, he started to functionally decline. He needed some assistance. So I was arranging for home health care to come in to help him out with hands-on care with his activities of daily living. As we've been told for so many years, the bathroom, I don't care how old you are, from little kids all the way up to big kids, the bathroom's the most dangerous room in the house. Yeah. And so really to assist with these, with his activities of daily living, and then he started to decline cognitively.
Okay.
And what I discuss with clients is that the only thing consistent about cognitive impairment is its inconsistency, especially at the earlier stages. If you speak with someone, you can think that they're just fine. And we discuss the difference between executive function, logic and reasoning, and knowledge. And cognitive impairment does not mean stupid. I can't tell you how often I have to explain that the person is still the brilliant person they've always been.
So that's another good point, because, we're talking to people that are going to either end up being caregivers or they are already caregivers. But it doesn't happen, like you say, it's a process, and it doesn't happen overnight that a person just all of a sudden has memory loss unless they have a traumatic brain injury.
Exactly.
But these are signs that you, as an elder law attorney, I'm glad to find out, you're educating your clients about what to look for in executive function, and prioritize these things, and to realize that this is the beginning, and to pay attention to it, because it only, like you say, it can get worse. It comes and goes. It's not always consistent. And these are things that people definitely need to be aware of. And we're going to talk about what they need to do about it in just a moment. But I'm so glad that this is part of the conversation, to educate people about how the decline happens. A person that has mild cognitive impairment doesn't necessarily mean they're going to get full-blown Alzheimer's, but mild cognitive impairment could be a precursor to that. So these are things that we all want to be aware of and look out for in our elderly family members or friends.
And what I do is, because I call it a journey.
Yes.
Because I've walked the journey personally. I mean, my grandfather's no longer living. I've walked the journey from beginning to end, so to speak. I've not just dealt with the issues professionally in advising families. I've actually been on the journey.
And so you've walked in their shoes, and you can identify with them, and you know exactly what they're going through. And that makes you extra special, let me tell you. As board certified, elder law attorney, and caregiver to boot, I'm telling you, you've got it all going there.
Well, I appreciate that. And one thing I do tell caregivers as they walk out of my office is I say, remember to breathe. When you're a caregiver, breathing is not an involuntary action. You actually have to remember to breathe. And when I say that, caregivers see that I get it.
Yeah.
And because very few people make that connection, but I've been in their shoes.
Yeah, which is great. So,
and that's why I went into elder law.
And that's why you went in, and you're still in, and you're still passionate about it.
That's correct.
So we're going to go to our first commercial break, but stay with us. We're going to come back with Sherry Greenblatt and lots more questions to ask her about the next steps, what you need to do to be prepared as we age and to help your loved ones. So we'll be right back.
Arden Courts is not just a place to live, it's a place to call home. Residential living combined with quality caregiving. This is the philosophy behind Arden Courts. Communities created exclusively for individuals with Alzheimer's disease and related dementia who would benefit from a safe and structured environment. For additional information about any of the unique services Arden Courts provides, call 888-478-2410 to locate a community nearest you. Inquire about our educational seminars, resource library, or support groups, or simply feel free to ask questions you may have about Alzheimer's and related dementias. At Arden Courts, we know, we understand, and we can help because memory care is all we do. Remember, call 888-478-2410 for additional information about any of the unique services Arden Courts provides.
The inability to recognize the obvious often occurs with Alzheimer's, particularly among the family members who care for them. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to us. We know. We understand. We can help. Arden Courts.
Disease and dementia care expert on caregiversolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
Welcome back. My guest today is Sherry Greenblatt. She is an elder law attorney, but she's also board certified, and her company is Florida Elder Law Concepts here in Boca Raton. And thank you, Sherry, for being here.
Thank you so much, Marcia.
There's so much that I want to ask you during our time today to pick your brain and let everybody take advantage of listening to your expertise and your advice. Let's get into the legal documents.
Okay.
Now, this is something everybody needs to do. It's not just for caregivers, and everybody needs to do it. But we're going to go through the most important ones, the basics, you know.
Oh, absolutely.
And tell everybody why it's important and when they should do it. So let's start with probably one of the most important, which is a durable power of attorney.
Okay.
That is when, what? You give somebody your power. But what does that really mean?
Okay, let's talk about what it means in English. You say durable power of attorney. Well, what does durable mean? We're not talking about garbage bags here. And so a durable power of attorney is a document wherein a person, typically the parent, the elder, or what have you, grants authority, so gives the legal right to the person or persons they name in the document to act on their behalf. More often than not, it's matters of finance, so paying bills, taking care of their brokerage account, signing contracts, hiring a home health care agency, or signing a contract for Arden Courts.
So someone can do that. Do you have to be sick in order for someone to do that? or can you just be out of town and they can do that, or do you have to be deemed incapacitated to be able to utilize a durable power of attorney? When is it used?
Okay, a durable power of attorney now, since 2011, when Florida redid their power of attorney law, is effective as of the time you sign the document. However, the law, when it changed in 2011, added a lot of restrictions, things that we think are common sense, like acting in the best interests of your parents if they named you on their power of attorney. That's actually written into the law right now.
So that gives a person leeway.
Well, it doesn't give them leeway. It actually restricts them because they have to do what's best. Let's say mom named son as her agent on a power of attorney. The son has to do what's in mom's best interests. He also has to do what he knows mom would have wanted. So if mom has had regular conversations about, well, if I develop cognitive impairment and I need, for safety reasons, let's say, to move to a memory care unit, and he knows that mom loves art and courts, that's what she would have wanted. And that's why communication is so important between the parents and whomever they're naming as their agents on the documents.
Well, I'm glad you said that, because I have had so many parents that say, I don't want my son or my daughter to be my power of attorney because they wouldn't do the right thing by me. They just want to get my money, or, we haven't talked in years. And so when you're naming somebody, these are things that you have to take into consideration.
Absolutely.
It doesn't have to be a relative.
No, it does not. And what I discuss with clients is that even though the law restricts how the agent acts, it is absolutely crucial they name individuals that they trust. And it does not have to be one of their children. It can be another relative. It could be their best friend. It can be a professional. There are other options. And I do advise clients that you do not name a child just because they're the eldest. If they're the best person and most trustworthy to name and they happen to be the eldest, then that's great. But being the eldest, or being a son versus a daughter, that in and of itself should not be the reason to name them.
So does the person being named, say the son, does he have to agree to be mom's power of attorney? Does he necessarily have to give his permission, or does he have a say-so in it? Or is it a done deal, or can he say, no, I don't want to do that?
You can't force anyone to act. If mom has done her documents and she names son on her power of attorney, and let's say he's a good son, he's trustworthy, but and this actually happened to a client, he's out of state and he's caring for his wife who has cancer, and mom needs assistance here in Florida, and he still, let's say, has teenagers at home, his plate's a little full.
Yes.
And he may absolutely want to take care of mom's affairs, but his plate might be too full to manage mom's affairs, and he may feel that he has no choice but to resign, which leads to why I recommend to clients naming more than one person.
Okay, that was my next question, because if somebody can't, in this case, or feels that they're not the best qualified, is there a backup? And you just said it's good to name a backup. What happens if the son says, I can't do it, I'm too far away, I've got too much going on with my life, and there is no backup named in the document? What happens then?
Well, then it depends. We'll just use mom as an example. At that point, if mom still has capacity, meaning she has a legal capability of signing documents, which is a bit more than just being able to physically sign her name. If she still has capacity to sign documents, then she should revise her documents and designate someone else to serve on her behalf.
Okay.
So if she doesn't,
having capacity, you alluded to, means more than just being able to sign your name. It means that they have to understand what they're doing, correct?
Exactly.
And they have to convince the person, I guess, who's preparing the documents that they do understand, at that time, at that point in time. And that
Absolutely.
might be difficult if a parent is starting to, getting some of the cognitive impairments, and it could be iffy. So that could be
difficult.
Difficult, yes.
Absolutely,
Yeah.
yes, it is. And that's why planning is so crucial. And people ask me, well, when should I sign a power of attorney?
Yeah, good question.
At what point should I sign a power of attorney? And my answer is, are you over 18? Now, it has to be over 18 because if you're under 18, your parents are your natural guardians and they get to make decisions for you, no matter how much our teenagers don't appreciate that. But if you're over 18, you have legal rights to act on your own behalf, and no one else has legal right to act on your behalf unless you have signed a document, such as a power of attorney delegating authority, or a court has decided that someone else can act on your behalf.
So just so I understand what you're saying, because I'm sure there are some people with
who are a little
questions
confused
out
with what
there.
I just said.
Right?
Absolutely.
So you're saying anybody that's over the age of 18 and maybe even starting at that age should be naming someone as their power of attorney in case they get themselves in a predicament or a situation where they can't make their own decisions.
Absolutely. So I had clients' children in my office. Now, in my practice, children or kids are usually in their 50s and 60s. And we started out the conversation. They came in regarding mom and dad and needing long-term care and making sure that family had authority to act. And then mom and dad were part of the conversation, and mom and dad were still relatively healthy, but starting some chronic conditions that had to be managed better by their physicians, etc., but still relatively fine. And speaking to the children, and the children, again, in their 50s and 60s, were saying how, we should put our affairs in order just in case. And then I said, okay, do you guys have children? Said, yes, we have one off in grad school and one going off to college this year. And I said, okay, so the one in grad school is over 18? Yes. The one going off to college this year, she turned 18? Last week, actually. So I said, okay, all of you need documents, including the children. Why? We write the tuition check.
Being a parent only gives you certain rights, I imagine.
Once they're 18. And I said, well, if you call up their schools and you ask questions, they're going to say, we need your children's permission. But I write the tuition check. Said, that's very nice, but they're over 18. And I said, but what's more important is health care. Mm-hmm. And I guess we're going to get into discussions of health care. I said, none of us want to think of this as parents. I mean, I have 3 children myself, about what happens if your child gets sick or there's something that happens away at school. And unfortunately, in today's day and age, we have had campus shootings.
Yeah.
And
all kinds of terrible, like, frat parties where, somebody might get hurt, and healthcare decisions need to be made for that person.
Absolutely. So I turned to them. I said, if you hear there's a shooting on your child's campus and you can't get through to them on their cell phone, because, teenagers these days, their cell phones are surgically attached to their hands. And what's your next step? And the mother pipes up, I'm calling the area hospitals. I need to know that my child's okay. Said, absolutely, but if you get through to the hospital, they will say we can neither confirm nor deny that your child is here. They are over 18.
Wow.
But
it's an eye-opener,
right?
It
really is an eye-opener. I said, but you do need to understand that if your children name you now that they're in the 18 to 22 category, more likely than not, 10 to 15 years from now, you will no longer be on their documents because powers of attorney, the person signing them, can make changes. It is their documents.
Because as they age and they might get married, they're going to want their spouse to be on because the parents are going to pass before them in a normal, life cycle.
But that applies to seniors as well and our elders. Many of my clients come in and a child, again, children being in their 50s and 60s, I had one client come in 2 weeks ago who said, I need to change my power of attorney and my healthcare advance directive. I named my son and my daughter-in-law. My daughter-in-law passed away. I need to change my documents. And I said, absolutely, they're your documents to change. I'm sorry for your loss, but you're doing the absolute right thing to make sure that your documents name the ones you want.
And that's so important. And I think this is just a great conversation to have, that people don't realize how this one document can affect the outcome of all kinds of situations.
That's correct.
So the point to this is get your durable power of attorney, get it early. We're going to take our next break. When we come back, we're going to talk with Sherry about more documents and the other very important documents that you need to have in your portfolio. So we'll be right back.
The inability to recognize the obvious often occurs with Alzheimer's, particularly among the family members who care for them. When the time comes for you to decide that someone you love needs more feelings of depression, isolation, and frustration are common among persons living with Alzheimer's or related dementias. It's common among those who care for them, too. It takes a lot of patience and courage. It also takes knowing when you can no longer do it alone. At Arden Courts, memory care is all we do. Talk to us. We know. We understand. Somewhere at the corner of bewildered and confused is a lost mother, a father, a sibling, a grandparent. Wandering is a common symptom of Alzheimer's or related dementias and can often make those who care for a loved one feel just as lost. If you're looking for a place that's safe and secure, look to Arden Courts. Memory care is all we do. We know, we understand, we can help. To learn more, visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines. Being unable to recognize the obvious often occurs with Alzheimer's or related dementias, even among their caregivers. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to Arden Courts. Memory care is all we do. We know, we understand, we can help. To learn more, visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines.
Alzheimer's disease and dementia care expert on caregiversolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
Welcome back. I'd like to take this opportunity to thank our national sponsor, Arden Courts Memory Care Communities. Arden Courts has 10 assisted living memory care communities here in the state of Florida and about 50 total across the United States. Arden Courts is a leader in memory care, and they are great as a resource wherever you are. This is a book that Arden Courts would like to give to you, a family caregiver, absolutely free. It's a gift just for the asking. This is a wonderful book called The 36-Hour Day, and if you're a caregiver, you could probably identify with that. Your days are trying to pack 36 hours into 24. This is a great resource written by Dr. Peter Rabins and Nancy Mace. It's a book that explains all kinds of differences between types of caregiving situations. It explains the different forms of dementia, lots of tips, lots of great advice. All you have to do to get this book is call the Arden Courts toll-free number, which is 888-478-2410. Again, 888-478-2410. Give them a call. Tell them that you heard about this offer of the free 36-hour day book on the Caregiver Solutions info show. They'll get your information and mail a book directly to your home. So give them a call today. You'll be glad that you did. So my guest today is Sherry Greenblatt. She's a board-certified elder law attorney. Her company is Florida Elder Law Concepts, and we're talking about all the things legal, the documents and situations that we'll come across as we get older, starting at age 18, we just found out. So we just finished talking about durable power of attorney, Sherry. So let's go to another very important document. It's called healthcare surrogate or healthcare proxy. Maybe you can explain the difference, but let's talk about what that one does for us and why it's important for all of us to have this document.
Okay. A designation of healthcare surrogate is a document wherein you would name someone or some persons, or more than one person, to make healthcare decisions for you. Now, you can designate in the document whether or not you want them to make healthcare decisions for you only if you no longer have the ability to do so, or, and this is, as you get older, recent becomes a very relative term.
As we get older, we're thinking, this isn't old, right?
Exactly. I talk about the recent power of attorney law, and it's 2011, and we're in 19. It's not that recent anymore. But same thing with the change in the designation of healthcare surrogate and the law that governs that. Florida law now allows for a person to name a healthcare surrogate who can make decisions, healthcare decisions, even if they still have the capability of doing so. However, if the person with the capability of making their own decisions dislikes the decision of the healthcare surrogate, it's the principal or the person who signed the document whose decision supersedes.
And that's only if they still have capacity.
And they would have to have the capability of doing so. That's correct. But what this allows for and is for, let's say, daughter who's named as healthcare surrogate on dad's designation of healthcare surrogate. We use mom for power of attorney, so we're going to switch to dad now. And dad named daughter, but dad's in early stages of cognitive impairment. And some days he's perfectly fine to be making decisions. He's still at that point. But other days, in discussions with dad, his ability for logic and reasoning is mildly impaired. So to have that ability without requiring a doctor or a court to state that dad's incapacitated, the daughter would be able to make decisions. But there's another very important part to this document, and that is authorization to access medical records, what we call HIPAA. We call it HIPAA because it's the Health Insurance Portability and Accountability Act of 1996.
It's a mouthful.
Oh, yes, it's a mouthful. Much easier to say HIPAA. And that goes to, well, who has access to your health records? And
doesn't a healthcare surrogate automatically have it? Or?
If you have the language in the document giving that authority, yes, they would.
So it's very specific. Again, like a durable power of attorney, it has specifics in there to address certain situations. So you have to be very careful that, I suppose, that everything is addressed in these documents that might come across your plate.
That's correct. So access to health information could be anything from dad asking daughter to call up for the blood results, the blood test results, or and I'm going to date myself now, or dad sending daughter to the imaging center to pick up the films of his list. Okay, it's not films anymore.
And now they can text them to you. But even at that, she would need authority to get them text
to get
or
the
email
report
or emailed to her.
Absolutely, and especially now with electronic medical records, being able to submit that. And also a lot of our children, again, don't live in Florida where their parents are. They're across the country.
Right.
And what the law has actually done is almost caught up to reality, and electronic medical records have been very helpful with this, is a daughter gets a call from an interested neighbor, your father was just taken 911, and the daughter, being an involved child, knows what the nearest receiving facility is, calls that emergency department and says, I know my father was just taken to you by ambulance. What's going on? And the emergency department says, well, who are you? We can't release information. She says, oh, yes, you can. What email am I sending the document to?
Okay, so in the good old days, right?
Exactly.
Before we had access, even before email, but now it's so easy, you can do it right on your phone. The daughter wouldn't have had the ability to get that information, would she? Unless she faxed it, maybe?
Then it would have been by fax.
Okay.
And when I first started in this area of law 20 years ago, I would suggest that those named, the healthcare surrogates, carry with them a physical copy of the document. Now, when I prepare documents for clients, not only do my clients get their original documents, I, with their permission, forward electronic copies to the individuals they have named in the documents. So if dad has named daughter who's in New York, with dad's permission, I send those documents to her electronically so she can download them and keep them on her phone, her tablet, her desktop, what have you, and be able to forward on an as-needed basis.
And I think that gives families and their elders peace of mind, knowing that if something happened to me, you know what to do, and you have the ability and the authority to do it.
Absolutely.
That's very, very important. And let's go to another one. It's called living will.
Okay.
All right. So what is a living will? And if we're living, why do we need a will?
It's very confusing because a living will is a totally different document than a last will and testament.
And that's where it can be confusing for people that never had to deal with any of these legal documents, that like a living will. Okay, I know what a regular will is, but so explain the difference between that.
Absolutely, because using the same word is beyond confusing. So that's why I spelled out last will and testament, because that's the full title of what we always call a will. And that's for you to put in writing where you want your assets to go after you're gone, after you pass away. A living will is a document which is really a roadmap for your healthcare surrogates to follow regarding your end-of-life wishes.
So the living will has to do with our person, our body,
that's correct.
What they're going to do to us or for us toward the end of life. And a last will and testament is more for things
that after we die
that you want to dispose of or give away to certain people.
That's correct. For a last will and testament to go into effect, so to speak, a person has to be deceased.
Right.
A living will is end of life care. So the last stage of life, when a person is terminal, when a person might be in a persistent vegetative state, where a person is completely physically dependent and completely cognitively impaired, or what we call an end-stage condition that a doctor has certified the person to be in. And it's giving instruction to your healthcare surrogate that if I'm in these conditions that I've spelled out in this document, do I want a feeding tube? Do I want to be on a respirator or a ventilator? Do I want surgery? Do I want dialysis? Do I want chemotherapy or radiation? What are my wishes?
And that makes it easier for the people that are caring for you
Absolutely.
to make that decision, because they know what you would want. They know your wishes, instead of having a lot of discord between various family members saying, no, I don't think she'd want this, or I want that. So it really resolves a lot of conflict, too.
It resolves conflict. It also helps relieve a lot of guilt. When someone's a caregiver, there's plenty of guilt. Am I doing the right thing?
Yes.
Am I doing what mom or dad would have wanted? And mom and dad aren't at the point where I can have that kind of conversation with them. I don't want to cause them distress if they still have capacity. I don't want to, they no longer have capacity. I can't discuss these issues with them. So it helps relieve guilt where they have it in black and white.
That's right there.
This is what mom wanted. Mom says specifically she doesn't want a feeding tube if she's in these types of conditions.
So that's what we're going to do.
And I'm following mom's wishes. I'm not making that decision.
Right, and you can't argue with that. So there you go. We're going to take our last break. When we come back, we have some more questions for the expert elder law board certified attorney Sherry Greenblatt. So stay with us. We'll be right back.
Thank you.
Feelings of depression, isolation, and frustration are common among persons living with Alzheimer's or related dementias. It's common among those who care for them, too. It takes a lot of patience and courage. It also takes knowing when you can no longer do it alone. At Arden Courts, memory care is all we do. Talk to us. We know. We understand. We can help. Don't let guilt keep you from making the right decision. Visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines. Somewhere at the corner of bewildered and confused is a lost mother, a father, a sibling, or grandparent. Wandering is a common symptom of Alzheimer's or related dementias and can often make those who care for a loved one feel just as lost. If you're looking for a place that's safe and secure, look to Arden Courts. Memory care is all we do. We know. We understand. We can help. To learn more, visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines. Being unable to recognize the obvious often occurs with Alzheimer's or related dementias, even among their caregivers. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to Arden Courts. Memory care is all we do. We know. We understand. We can help. To learn more, visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines.
Remember, call 888-478-2410 for additional information about any of the unique services Arden Courts provides. You are listening to your host, Marcia Teal, an Alzheimer's disease and dementia care expert on CareGiverSolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
Welcome back. I'm talking to board certified elder law attorney, awesome person, Sherry Greenblatt, with practice here in Boca Raton, about legal documents. And Sherry, we've talked about durable power of attorney. We've talked about living will. We've talked about healthcare surrogate. Those are basically the minimum type of documents that people would want to go and have it ready before a crisis happens.
Absolutely.
So that would involve planning. But there's another document I think it's important to talk about, and that's a DNR, which stands for Do Not Resuscitate. What's the difference between healthcare surrogate and do not resuscitate, or is do not resuscitate included in a healthcare surrogate? Because it sounds like it could, because it's about your healthcare, and in a living will also about what you want, what you don't want. But let's talk a little bit about DNRs.
Okay, a DNR, a do not resuscitate, is actually a DNRO. It's a do not resuscitate order. So an order, I don't mean from the courts. A do not resuscitate order has the signature of a physician on it.
Okay.
So a healthcare surrogate document, a designation of healthcare surrogate, is where you would provide the authority for your surrogate to sign, because it must be signed by you or your representative and a physician. So the designation of healthcare surrogate would be the document wherein you give your surrogate or surrogates the authority to sign on your behalf. Sign this do not resuscitate order on your behalf in conjunction with your physician, who would sign as well. Now, a living will is a document where you would state whether or not you want a do not resuscitate order on your records. Go ahead.
Yeah, I know. You know my question.
Go for it.
So in a living will, if a person states, I want a DNR signed, I want an order signed
Correct.
to not to be resuscitated. But if there's never an order, a separate piece of paper, order, especially like the way we do here in Florida, because other states can be different.
Every state is different. I'm only discussing Florida.
We're only talking Florida. So if in that living will, the person says, I don't want to be resuscitated, but if that healthcare surrogate or the person themselves never follows through and signs a DNR and has that order on file or that piece of paper, then it doesn't matter, right? Because you don't have the order, or is it like technical wishy-washy language, or how does that work?
How does that work? And this is where it's so important for a person who designates a surrogate to have open communication. Not just sign documents, put them in a safe, and walk away and never tell your healthcare surrogate they're the ones named. No, it's important to have ongoing conversations. Know if the person you've named is going to be involved in your healthcare, not just taking the doctor's call at work and saying yes, no, and hanging up on them because they have to get to a meeting. And to really be involved. And also, if the person, we'll take two different scenarios. A person moves into, let's say, Arden Courts. Arden Courts, I've had a number of clients at Arden Courts over the years, and to discuss with Arden Courts and the physicians, of course, what is in the file, what does your mother who has just moved in here want? And I know Arden Courts is one of the facilities that will actually have that conversation.
Absolutely.
And it will come up in conversation. It's being an advocate. You're not just a healthcare surrogate named in a legal document. That gives you the authority. But it's so important for that person to be an advocate, to follow through on a parent's wishes and ask the questions. But there's also a difference with a do not resuscitate order at home.
Okay.
Because
real quick, because we're running out of time.
Real quick, because back in 2000, Florida Department of Health changed the do not resuscitate order at home. It took out the words terminal condition. So it is important to give your healthcare surrogate the authority to sign it at the appropriate time.
So in other words, it doesn't have to be a terminal condition like Alzheimer's or cancer. It could be do not resuscitate if I fall down and now I'm brain dead or something, like a crisis.
But, most people don't want to have a do not resuscitate order if they just fall at home and they're otherwise healthy and the paramedics, or relatively healthy, and the paramedics come. If they bang their head, they want those paramedics to resuscitate if that becomes a necessity. But what about someone who has been told their cancer has metastasized and they're in stage 4, and they've been given, they're on hospice, not for palliative care, but for end-of-life care, and what are their wishes at that point?
And that's where it comes really
they don't
important.
want to be in a facility. They want to pass at home.
That's right. So that's very important designation.
Absolutely.
So there you go, the difference. So I love having you here. Thank you for coming and
Thank you so
sharing
much.
with us. Please give everyone your information, how to contact you if they'd like to follow up.
Okay. My name is Sherry Greenblatt. My law office is in Boca. My phone number is 561-245-4620, and can always reach me by email. It's Sherry, SHERRI, @ and I'll spell out, it's the acronym for my firm. So it's F as in Frank, L as in Larry, E as in Edward, L as in Larry, C as in Charlie.com.
Wonderful.
Thank you so much.
I am so glad you're here. Give Sherry a call. She'll be very happy to talk with you. She's a wealth of information, and you can see she's very knowledgeable and a nice person,
you,
too. So thank you again for being with us today. And thank you for tuning in. Don't forget to call Arden Courts to get your free book, The 36-Hour Day, at 888-478-2410. And we'll join you next week, same time, same place, every Tuesday, 5 to 6 p.m. In the meantime, don't forget, give somebody a hug because they need it, and so do you. We'll see you next time.
Thanks for joining us for this week's Caregiver Solutions with Marcia Teal. Join us next week as Marcia, who has 15 years of Alzheimer's disease and dementia care experience, brings you more needed information to help with the care of your loved one. This show can be seen again on caregiversolutions.info, and questions can be left on the site, which may be used on the program to help others. See you next week for more Caregiver Solutions.